Hello everyone, Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome again with the third lecture, with the second lecture 2, third lecture of the chapter, but lecture 2 of our video series of business law. I welcome everyone. Hope everybody's fine and doing great, and may Allah save us all from the pandemic COVID-19, and hope that you guys are studying well and enjoying your time at home with lectures and all that. So inshallah, in today's lecture we will once again have a previous lectures review, and then we'll mainly discuss our new topic, which is essentials of valid contract. So let's go and discuss the previous lecture. In our previous lecture, we had discussion on Contract Act 1872. This law means contract law is called Contract Act 1872 because this law was passed by the business society, proposed by the business society, and then passed by the state in that time, which was 1872. So it is called Act. You know why it's called Act? Previously we had discussion on this. We called this law Act because this law was proposed by the society, by the people of society, which is business society, and then passed by the state in 1872. That's why all the laws in the contract law, they are called Contract Act 1872 as a whole. We had discussion on contract itself, and we said that contract is a legal agreement between two parties which is enforceable by law. So a legal agreement is that agreement in which both of the parties are competent, they are aqil baligh and not mujrim. There is legal obligation between these two parties. They have free consent, and the object is lawful. Enforceable means that this contract is accepted by the law, by the state, and a contract is accepted by the state and by the law only and only if this agreement has those four characteristics which I earlier mentioned. So legal agreement is also called a business agreement, an agreement between two parties which is carried out, which is enacted in order to benefit one another, right? And also it has those four characteristics that I mentioned. Number 2 is agreement. So agreement is basically promise plus consideration. A promise, and this promise should have consideration, should have economic benefit for both of the parties. We will discuss promise later on. Let's talk about the agreement. Agreements are of two types: legal agreement or business agreement, and social agreement. So among these two agreements, legal and social, only legal agreements can be contracts. What is legal agreement? Legal agreement is an agreement between two parties which create legal obligations between them and which is enforceable by law. And social agreement is an agreement between two parties which create social obligations between two parties, and this social agreement is not enforceable by law. That's clear? Now let's talk about the promise. What is promise? Promise is basically a proposal or offer by one party and acceptance by the other party, and both of the parties should have free consent. Consent means razamandi, free means khud ikhtiyar wala. So a proposal accepted with free consent is a promise. What is offer? Offer is basically showing consent, or we can say razamandi, to other person to do something or not to do something, whether economic benefit for both, right? So basically everything starts from the offer. When an offer is made and that offer is for economic benefit for both of the parties, and in that offer is with free consent, and then this offer is accepted by the other party with free consent, this offer becomes a promise, right? Then if this promise has legal consideration or lawful consideration, right, then it is a legal agreement and it becomes a agreement. Now agreement which is legal and it enforceable by the law, it becomes a contract. So if I say A is equals to B and B is equals to C, right? Suppose this is A is equal to B, and then B is equal to C, and then C is equal to D. Then we can say that A is equal to D, which means that a contract is an accepted proposal, right? So that's all about our previous lecture, right? Now we will have discussion on our new lecture, and our new lecture is essentials of valid contract, right? So first of all, let's define what is a valid contract. So a valid contract is binding, all or compulsory and enforceable, right? In a valid contract, all the parties are legally bound to perform the contract. Basically, this is not the definition of the valid contract. It is like elaboration or explanation of the valid contract, which says a valid contract is binding, compulsory, ijbari de, and enforceable. Kaswa ke na ki no, kaswa ke na ijra ki no, tatbiq qanun pe ki ya mahkama ki. Aw in a valid contract, all parties are legally bound to perform. The contract valid تمام جوانب یعنی هر دو جانبین قانونی مجبور و مکلف هستند که اجراتشان رو بکنن. کسی که اجرات نمیکنه، پیشتر ما براتون گفتم که او باز محکمه میشه. Thus a contract can be enforced by either of the party. If one party refuses to perform the contract, the other party can enforce it through the court. محکمه باید بکنه، تونه که خودش حاکم شوه و قانون را با دست خود بگیره، خودش یک جرم است. کسی که انکاری میشه، کسی دیگه طرف باید با قانون مراجعه بکنه، با محکمه مراجعه بکنه. To be enforceable, an agreement must own the essentials of the valid contract. همین definitionشان است. خب valid contract چی است؟ A valid contract is a contract which contains or consists all the essentials of a contract mentioned in the law of contract, right? So once again we can say, what is a valid contract? A valid contract is a contract which consists all these essentials, right? All these essentials. These are the essentials mentioned in the law of contract. So we can say that a valid contract is a contract which consists of all the essentials mentioned in the law of contract. And the essentials which are mentioned in the law of contract are these 10, right? Offer and acceptance, lawful consideration, lawful obligation, lawful object, free consent, capacity of parties, certainty of terms, possibility of performance, writing and registration, not declared void, right? All these are the essentials. Now let's discuss them all one by one. A contract which is missing one of these essentials is not called a valid contract. It's something else. Then inshallah, then we will discuss that in the second chapter. So the first one is offer and acceptance. For an agreement, there must be a lawful offer by one party and lawful acceptance of that offer by the other party. Lawful here means that the offer and acceptance must satisfy the requirements of the Contract Act, and that is that this offer should not be in the risk of the other party, if in the risk of the third party, right? The offer should be lawful or legal. It should not be illegal, right? Then number 2 is legal obligation. Obligation means duties and rights. Duty is something that you perform, and right is something that the other party should perform to you, right? So both duties and rights should be legal. No illegal or unlawful duties or obligations should come into existence as a result of an agreement, right? So the parties to an agreement must create legal obligations. It means that if one party does not fulfill his or her promise, he or she shall be liable for the breach of the contract. It is presumed or supposed in commercial agreements that parties aim to create legal obligations. So legal obligations means that this agreement should be created in order to benefit both of the parties, right? And both of the parties should benefit from this agreement, and it should be legal benefit, not illegal benefit. So if one of the party breach here means to break the contract, to refuse the contract, then other party has legal right to sue him to the court. There are some examples. Example number 1 is for offer. Ahmad offers to sell his bicycle to Bilal for 2000 Afghani. This is an offer. If Bilal accepts this offer, there is an acceptance, right? If does not accept, it remains an offer and it finishes. Ali offers to sell his watch to Bilal for $200. Bilal agrees to buy. It is an agreement, it is in a contract, and it creates legal obligation. Here you see there are two parties. Now there is another example, which is real example, in which a husband promised to pay his wife an allowance of $30 every month. Later the parties separated and the husband refused to pay. The wife sued, and this was decided that the wife was not entitled, as the agreement did not create a legal obligation. So here a contract between husband and wife was a social contract. Husband promised to help her wife while she is in her wedlock or nikah, and that was a social agreement. When that promise finishes, that contract finishes, then this second contract also finishes, which is of paying her $30 every month. So this was happened in 1990 between Balfour versus Balfour. So the first Balfour is the husband, the second Balfour is her wife. Okay, I'll conclude all these essentials at the end of the lecture. Now let's go to the next slide. Lawful consideration. What is lawful consideration? For a valid contract, the consideration should be lawful. Consideration is the price paid by one party for the promise of the other party. So that price, that benefit, economic benefit, is consideration, which is paid by one party and received by other party in a contract. This consideration could be in form of money, it could be in form of any other physical object. An agreement is enforceable only when both of the parties give and take something. That something given or taken is called consideration. Understood? Something given or taken is called what? Consideration. Number 4 essential is capacity of parties. Capacity means competency, and this is what I have also explained in my previous lecture. But let's see again. An agreement is enforceable if it is made by parties who are competent to the contract. To be competent to the contract, it is essential that the parties are of age of majority. Number 2, have sound mind, and number 3, not disqualified from contracting by law. امو سی چیزای ما براتون گفته بودم که بالغ باشه. ایج آف میجورتی، میجر کسی را میگه که از 18 سال بالا سن داشته باشه. قانونا عمر میجورتی که است، عمر بلوغت قانونا او که از 18 سال است و در یگان جای 21 سال است. صحیح است؟ ولهذا کسی که در کانترکت انتر میشه و حداقل قانونی عمرش باید 18 سال باشه یا از 18 سال بیشتر باشه، یعنی 21 سال باشه خوبتر است، بهترتر است. ساوند مایند چی معنی که بالغ عاقل باشه. کسی که عاقل نباشه، دیوانه باشه یا در وقت کانترکت سر حال نباشه. right سر حال نباشه دا معنی چې هغه نشوي یا کوم سیز ورکړی شوی وي چې هغه د خپل دماغ خپل کنټرول کې نه وي، نو دې کس ته مونږ عاقل نه وایو، ته مونږ انساوند مایند وایو. صحیح ده؟ او دریم دا د چې ډیسکوالیفاید فرام کانټراکټینګ بای لا نه وي، قانون هغه د کانټراکټ کې انټر کېدو نه منع کړی نه وي، مجرم نه وي. مجرم کس هیڅ کله کانټراکټ نشي کولی، که هغه میجر هم وي، بالغ هم وي او عاقل هم وي، خو چې قانوني په هغه باندې بندیز لګېدلی وي، نو هغه نشي کولی چې کانټراکټس کې انټر شي. صحیح ده؟ نو کپاسټي اف پارټیز لپاره دغه درې شیان دي: بالغ، عاقل او مجرم باید نه اوسي. صحیح ده؟ نو څلورم essential of the valid contract هم دا دی چې کانټراکټ باید څه اوسي؟ عاقل، بالغ او مجرم نه اوسي. نو هغه پارټیز کولی شي بیا کانټراکټ کې انټر کړي. دلته examples دي. Mr. Ahmad agrees to sell his house to Bilal for 1 million Afghani. For 1 million Afghani, for Ahmad 1 million Afghani is the consideration, and for Bilal house is the consideration. ببین یک چیز داده گرفت ما گفته بودم که consideration گفته میشه. از یک طرف پیسه داده میشه، از دیگه طرف خانه گرفته میشه. صحیح است؟ با یک طرف پیسه consideration است، با طرف دیگه خانه consideration است. فلهذا این یک valid contract است. خب دیگه مثال دوم اگه شما ببینین، اینجا invalid contract است به خاطر که considerationش unlawful است. ببینین شما Mr. A یا احمد promises to Bilal to get him a government job and Bilal promises to pay 100,000 Afghani. اینجا ببینین یک کار غیر قانونی است که به ما کار پیدا که ما باید پیسه میتم. This agreement is void or invalid as the consideration is unlawful. قانون این کار درست نیست، فلهذا ایرا ما unlawful consideration میگم و agreement که the contract که unlawful consideration باشه او invalid contract گفته میشه. غلط contract است، صحیح contract نیست. خبل example ده Mr. Mahmood, a person of unsound mind, agrees to sell his house to Sarwar for 2 lakh Afghani. It is not a valid contract because Mahmood is not competent to the contract. دلته یو لیونی سړی دی هغه خپل کور خرڅي، نو لیونو کسانو سره مونږ کانټراکټ نشو کولی. صحیح ده؟ دا قانونا جرم دی او غیر قانوني کار دی. دارنګه بل اگزامپل کې تاسو وګورئ. اگزامپل نمبر डी کې دلته یو کس 40 کلن دی او بل کلم خاصه عمر لري، د ذهن نوم برابر دی، قانوني مجرم هم نه دی، بندیز هم پې نشته. نو که دوی خپل منځو کې اګریمنټ وکړي، if they do agreement between them, so that is a valid agreement. Now we come to number 5, free consent. Alright, what does free consent mean? Free consent means that both of the parties, the one who makes a promise should have a free consent. The one who accepts a promise should have a free consent. And what does free consent mean? Free consent means that both of the parties consent, razamandi, is not obtained by force, by undue influence, or by fraud or misrepresentation. دا معنا چې د وچا رضامندي مونږه په زوره، په چال او فریب باندې او په سوء استفاده د قدرت نه او دغسې نور شیانو نه چې هغه د هغه رضامندي پکې مجروح کیږي موږ نه وی ترلاسه کړي که موږ دغه if we have obtained the consent using one of these like force, undue influence, or we have made a fraud or misrepresentation says or mistake, then this contract is not a valid contract. یا موږ غلطی نه ناخواسته موږ نه یو خبره شوی وي هغه او خبره دروغ وي او د هغې په خبرې په اساس باندې یو نفر موږ سره اګریمنټ کوي دا هم valid agreement نه دی چون دغه کس کانسنټ په دې کې فری نه دی چې هر کله هغه د حقیقت نه خبر شي هغه چې ولا دا خو ما سره ظلم شوی دی فلهذا نه به موږ غلطي کوو نه به موږ دروغ وایو نه به موږ چې دی خپل د هغه نه سوء استفاده کوو نه به چا باندې فشار راوړو صحیح ده نو هر هغه کانټرکټ صحیح دی هر هغه کانټرکټ که فری کانسنت باشه valid است و فری کانسنت ایمانا که ما رضایت خود را اگر ما آفر میکنیم با رضایت خود ما باشه اگر ما اکسپت میکنیم رضایت خود ما باشه یا جانبین آفرر این کسی که اکسپت میکنه آفره اونا باید چی بکنه اونا باید رضامندی خود اختیارانه داشته باشه صحیح است رضامندی از اونا را با زور یا با سوء استفاده از قدرت یا ای که دروغ برش گفته باشیم فریب داده باشیم باید به دست نبیاریم صحیح است اگر تو کانترکت صورت میگیره او کانترکت درست نیست lawful object it is necessary that agreement is made for a lawful object the object of agreement must not be fraudulent illegal immoral imply injury to the other person or property of other person کوم سیز باندې چې موږ تجارت کوو هغه کوم سیز چې موږ خرڅو so that object which is traded which is given or obtained between the parties it should not be fraudulent it should not be illegal it should not be غیر اخلاقی immoral it should not be something which could cause injuries to other person or it should not be the property of other person داسې نه چې یو سیز دوکه ورکوونکی سیز وي غلط چیز وی غیر قانونی چیز وی غیر اخلاقی چیز وی یا یک چیزی که باشه که او بندگرا جراحت میکنه مجروح میکنه کسا مثال بم چاقو بوکس پنجه و غیره و غیره سلها و همچنان چیزی باشه که مربوط خودت باشه مالکیت کسی دیگه نباشه صحیح اگر یک چیز فریبی است یک چیز غیر قانونی است یک چیز غیر اخلاقی است یک چیزی که هست که به مردم تاوان میرسانه یک چیزی هست که مربوط خودت نمیشه پراپرتی کسی دیگه است او دیگه unlawful object است شما نمیتونین که سر او در کانترکت داخل شن اگر کدام کانترکت یک چیزی unlawful داشته باشه او کانترکت valid نمی باشه صحیح است و این مطابق ماده سکشن 23 کانترکت لا این گپا ذکر کردم خب انشالله یک چیز در ذهنم آمد که در آخری لکچر براتون میگم وقتی که این لکچر ما کنکلود میکنیم باز در آخرش ما چیزا رو براتون بحث میکنیم صحیح خب در جمعه مال سر مثال مثال اول درباره فری کانسنت است میگن که احمد compels or forces Bilal to enter into a contract at gunpoint. It is not valid contract as the consent of Ahmad is not free. احمد بلال را مجبور میسازه و به زور تفنگ سرش یک چیز میقبولانه این کانترکت درست نیست این احمد میتونه که به محکمه مراجعه بکنه و حق خود به دست بره بخاطر که سر ظلم شده B example B Ahmad promises to pay 5,000 Afghani if B beats C. This agreement is illegal as its object is unlawful. پدې کې احمد بلال ته وایي چې زه به تاته 500 افغانۍ درکړم که ته راپاسې او شکر الله وډبایې صحیح ده نو دا داسې عمل ده چې بل ته پکې نقصان رسیږي فلهذا این کانترکت درست نمیباشه به خاطر که این کانترکت با دو نفر به وجود آمده ولی این کانترکت با نقص یک نفر سوم است فلهذا این کانترکت صحیح نیست مثال سوم رو ببینین احمد hires a house to use for gambling. The object of the agreement is unlawful, so the agreement is illegal. قمار د لپاره یو کور په کرایه اخلي نو دغه د کرایې کانټراکټ چې دی اوس دا څه چې دی دا unlawful دی یعنی illegal agreement دی. اوس راځو بل هغه ته بل essential موږ سره دی writing and registration. A contract made by oral or in writing, it is preferable that the contract may be in writing because it is easy to prove in court. If required by law, a particular contract must be in writing, signed, attested by the witnesses and registered. For example, sale or mortgage of the land. Now, her contract باید څه شي ولیکل شي تمام شیان پکې واضح شي او هغه باید بیا څه شي راجستر شي په محکمه کې راجستر شي. بعضې داسې کانټراکټس دي چې هغه د هغې لیکلو ته ضرورت نشته دی نو هغه که هم نه لیکي نو مشکل نشته صحیح ده. لکه واړه کانټراکټس چې دي مثال ته مارکیټ ته ځې مارکیټ نه یو څیز اخلي پیسې ورکوي خبره ختمه ده. نو دې کې لیکلو ضرورت نشته چې زه وایم چې ښځه دومره شیان اخلم یا ته ما باندې خرڅې هغه بیا دوباره وایي چې و دومره شیان په تا باندې خرڅوم هغه ټول شیان ولیکي بیا ورشي محکمې کې هغه راجستر کړي بیا ورته پیسې ورکړي. دې ضرورت نشته دی چې کوم ډیلی لایف کانټراکټس دي ډے ټو ډے کانټراکټس صحیح ده نو هغو ته د لیکلو ضرورت نشته. خو که داسې کوم کانټراکټس دي چې هغه باید عقل او منطق او حالت داسې وي چې دا باید ولیکل شي نو هغه باید ضرور ولیکل شي هغه په یو قانوني کاغذ باندې محکمې مخ ته کاغذونه ملاویږي سرکاري کاغذ دی it's official document په هغه کاغذ باندې باید ولیکل شي او بیا یو وکیل یا یو لایر وکیل مدافع چې ورته وي هغه پبلک نوټریک هم ورته ویل کېږي هغې مخامخ باید هغه امضا شي ګواهان به کې خپل امضاګانې وکړي خپل شرطونه کېږي او هغه باید په محکمې سره راجستر شي. دا کوم قضای دولت چې ورته وي که نه قضای دولت کې باید دا رجستر شي او قضای دولت کې باید دا ولیکل شي په یو کاغذ باندې په یو افیشل کاغذ باندې صحیح ده. نو دا هم ډیر مهم دی د دې لپاره چې بیا که سبا څه مشکلات پیدا کېږي نو دا موږ سره ډیر کومک کوي. اتم نمبر موږ سره دی certainty of terms or sureness of terms. دا معنی ورکوي ما باید تو الفاظ استفاده نکنیم که چندین معنی داشته باشه صحیح. اگر کدام لفظی تو استفاده میکنیم که چندین معنی داره در اونجا باید مشخص بسازیم که در این کانترکت از این لفظ منظور ما چی هست. معنی چیز که هر چیزی که ما نوشته میکنیم هر لفظ باید مشخص باشه. مثال تعداد، مقدار، کوالیتی، رنگ، همه چیز. مثال یک چیز ما میخریم ما میخوایم که یک 200 دانه تلویزیون بخریم این باید مشخص باشه که 200 تلویزیون چند اینچ است مربوط کدام کمپانی است کدام برند است رنگش چی است کدام گیجتس داشته باشه در کدام وقت باید آورده شوی همه چیزا باید واضح شه. و اگر در ضمن کدام لفظی تو استفاده ما میکنیم که چندین معنی داشته باشه او را باید در مداخل خود بادی کانترکت واضح بکنیم که لفظ چی معنی داره. So this means certainty of terms. هر مو کانترکت چې دا غي terms واضح نوي نو هغه ته مونږه هغه کانترکت صحیح نه دی هغه تخنیکی مشکلات لري هغه بیا پاینده کې مشکلات جوړي او قانوني بڼه هغه نه لري. فلهذا a contract should have certainty of terms. Next we have okay, there are examples. I'll read only the first and the last example. X verbally promises to sell his book to Y for 200 Afghani. It is a valid contract because the law does not require it to be in writing. اوس بس افغانو لپاره خو موږ نشو کولی چې محکمې ته ورشو در نو قانونا دغه شی که موږ دغه کانټراکټ که موږ ونه لیکو څه مشکل نشته صحیح ده. که چېرته کوم غټ کانټراکټ وي کوم غټ کار وي چې هغه کې ډېرې پیسې انوالو وي او ډېر کارونه پکې انوالو وي یعنې مغلقه وشي نو هغه باید ولیکل شي هغه باید رایټینګ رجسټریشن د هغې باید وشي. ښه ډي نمبر ته راشئ. O agrees to purchase a car from S. The price was to be paid over 2 years. Held there was no contract as the terms were not certain about rate of interest and mode of payment. دو نفر د خپل منځ کې کانټراکټ کړی دی چې موږ به ګاډي به در باندې خرڅوم او په 2 کالو کې پیسې درکوم. نو اوس دلته معلوم نه ده چې کوم قسم د ګاډی دی، کوم موټر دی، کوم ماډل دی، کوم رنګ دی، څه مشخصات لري، څومره پیسې دي، دا پیسې په څومره 2 کاله کې خو ورکوي، خو څومره وخت پس ته څومره پیسې باید ورکول شي دا معلومه نه دي. فلهذا دا invalid contract دی، غلط کانټراکټ دی. صحیح ده؟ نو دا هغه certainty of terms لپاره یو مثال ما تاسو ته وړاندې کوم. Next we have possibility of performance. A valid contract must be capable of being performed. In an agreement to be impossible to do an impossible act is void. If the act is legal or physically impossible to perform, the agreement cannot be enforced by law, and this is section according to section number 56. چې کله مونږ یو کانټراکټ کوو هغه باید منطقاً او حالاتو د لحاظ نه باید په هغه وخت کې د هغې اجراعات لازم وي، د هغې اجراعات څه وي، امکانات ولري. که داسې یو کانټراکټ مونږ کوو، داسې یو شي باره کې کانټراکټ کوو چې د هغې اجراعات منطقاً اقلاً او د حالاتو په اساس باندې ته ګوري چې هغه ناممکن دی، نو داسې یو کانټراکټ کول چې دی هغه غیر قانوني دی. مثال یو نفر وایي چې زه ته ما دومره پیسې راکړه او یا دغه کار ما ته وکړه، زه بدل کې تا ته د اسمان نه ستوري راښکته کوم. نو اسمان نه ستوري خو څوک نشي راښکته کولی. صحیح ده؟ یو نفر تا ته وایي چې ته ما دومره پیسې راکړه زه تا جرمني ته رسوم، نو جرمني ته چې ظاهره نه ګورې، نو چې نه پاسپورټ ونه لرې، ویلډ ویزا ونه لرې، دغه جرمني ته نشي تللی. نو چې یو کس داسې واده کوي او بل کس ورسره مني، نو دا دواړه مجرمین دي او دا کانټراکټ صحیح نه ده، ځکه د دې پاسبیلیټي اف پرفارمنس نه پته لګي چې دا د دې پرفارمنس چې دی هغه امپاسبل دی، پاسبل نه دی. رایټ؟ سو هر وقت که کانترکت ما میبینیم که ظاهرا اجرات از او ناممکن است، دیگه او کانترکت درست نیست، دیگه او باید ما انتر نشیم. خب دوم نمبر not expressly declared void. این تو یک کاری نباشه، این تو یک عملی نباشه که او از اول على الانان یا علنی که ما میگیم على الالان او منع شده. سنیسته؟ مثال دولت اعلان کرده که این کارا را باید کس نکنه و باز ما میشینیم برادر دو اگریمنت میکنیم، دیگه این کانترکت ما invalid میباشه. سنیسته؟ مثال دولت اعلان کرده که در روزهای قرنطین کس باید خرید و فروش نکنه، دیگه کس میکنه یک کانترکت غیر قانونی است. اگر مثال پسند اینا بین زنا کدام مشکل پیش میاد و اونا در محکمه مراجعه میکنه و محکمه ثابت میشه که در وقتهای قرنطین بوده که هیچ باید بزنس صورت نمیگرفت، فلهذا این کانترکتشان قانون را قبول نمیکنه، هم ایرا سزا میده و همون را سزا میده و جانبین حق خود به دست آوردن نمیتونه. فلهذا ما باید در چیزی کانترکت نکنیم که او از طرف دولت هغه چه ده علی الاعلان هغه غیر قانونی اعلان شوی او مونږه باید پاغو کې کانترکت ونه کو. صحیح ده؟ So the agreement must not be one of those agreements which have been expressly declared to be void by the law. Section number 24 to 30 explains certain agreements which have been expressly declared to be void. Agreement in certain in the example is agreement in restraint or command of trade and wager or gamble or expressly declared void. نو مثال افغانستان دولت بعض شیان که واضح دي چې هغه غیر قانوني دي، نو هغه چې کوم شیان واضح هغه لیکلي دي چې دا غیر قانوني دي، نو په هغه شیانو کې موږ باید کانټرکټ ونه کوو. صحیح ده؟ خو اوس راځو د دغه لیکچر هغه وایند اپ تاسو ته زه وایم چې valid contract موږ هغه ته ویل کېږي، هغه ته وایو چې په هغه کې دغه لس essentials موجود وي. So let me talk in English so everybody understand. Valid contract is the contract which consists of all these 10 essentials. If one of these essentials is missing, that contract is not called valid. That could be void, that could be invalid, that could be illegal. So that contract then has some other name, not valid contract, because it has some technical issue. So those 10 essentials are offer and acceptance. I have put them in a very logical order. So if you think of these 10 essentials and notice the series of them from 1 to 10. It has connection to one another, and then you can easily learn. And one thing important, that if you want to learn business law and contract law, these 10 essentials are of utmost important. Means without knowing these 10 essentials, you cannot go ahead and further study the business law. These are the basis of the business law, and I most of the times advise my students to learn the concepts of these 10 essentials and the names of these 10 essentials as if it's your name. Like, very quickly you should remember. So let's start. The first one is offer and acceptance. A contract starts with an offer, and then if that offer is accepted. If an offer is made and not accepted, the contract cannot come into existence. Without offer and acceptance, contract cannot come to existence. Number 2 is lawful consideration. When you make an offer and then offer is accepted, there should be some benefit for both of the parties, and that benefit should be lawful. So that's why we call the second essential to be lawful consideration. The third one is lawful obligation. We studied that when agreement come into existence, this agreement gives obligations to both of the parties. So these obligations, right, they should be lawful. They should not be unlawful, right? And obligation are duties and responsibilities. Number 4, lawful object. The object which is exchanged between the parties should be lawful. It should not be an object which harms other person, which does not belong to you, which is fraudulent. So it should not happen. An object should be the lawful. So if you look at the connection between these 4, we say offer and acceptance with a consideration, and then there should be obligations to both of the parties, and there should be also lawful and legal. And then object, which is the main exchange in the contract, should also be lawful. Then offer and acceptance, all this agreement should come into existence with a free consent. So number 5 is free consent. Free consent means razayat khud ikhtiyarana. And we discussed that the consent, the razayat, should not be obtained with the force, with undue influence, with misrepresentation, with mistake, with lies, right? So if consent is obtained by these 4, that consent is not free. When consent is not free, there is no contract. Number 6, people, parties who are entering into a contract, who are making proposal and then accepting, who are considering some economic benefit to one another, and who want to perform some legal obligations, who want to exchange the lawful object with a free consent. Those parties should have capacity. They should be capable of entering into a contract, and capacity comes when the parties are major, baligh, they are of sound mind, aqil, and not disqualified, mujrim na basha. Says, then certainty of terms. Whenever we enter into a contract, all the terms and conditions that we specify, that we mention to one another, those should be specific, those should be certain, clear, mushakhas, defined, malum, right? And we should not use words which have multiple meanings. If such is the case, then we should explain the word, what is the exact meaning of that word in that contract. Next is possibility of performance. This contract, which has been accepted and proposed and accepted, and there is consideration, there is lawful object, there is lawful obligation, there is free consent, the parties are of capacity, and the terms are certain. The performance of this contract should also be logically possible, right? And then when everything is okay, number 9 comes writing and registration. We should write them and then we should register them in the notary public, qazai dawlat. And number 10, we should not enter into an agreement which is declared void, which is already declared void. Void means illegal. So illegal contracts should not be done. So that's all about our today's lecture. One thing that I mentioned earlier that I will have to explain to you was about related to offer and promise. So let me explain offer. When an offer is made, so there are two parties, party A and then party B. The party who makes the offer is called offerer, right? And the party to whom the offer is made is called offeree, right? So offerer and offeree, right? Offerer and offeree. When an offer is made, at the time of making the offer, the parties, the first party making an offer is called offerer, the party to whom the offer is made called offeree. Now when that offer is accepted, it becomes a promise. It becomes what? Promise. When offer is accepted by party B, this offer becomes a promise. When rejected, there is nothing. So when promise comes into existence, again there are two parties, party A and party B. The person who accepted the offer is called promiser. The person who accepted the offer. So here we say, if you look at the above example, A made an offer, so A is offerer and B is offeree, right? Now B has accepted the offer, so here B becomes the promiser and A becomes the the promisee. So promiser is the person who has accepted the offer, and promisee is the person to whom the promise is made. So if you look at the above example here, right, see, an offer was made by Ahmad to Bilal. So Ahmad was offerer, Bilal was offeree. Now Bilal has accepted the offer, so this offer becomes a promise. Now Bilal is promiser. Before he was offeree, now he is promiser, and Ahmad is promisee, right? So hope it's clear now, and this was very important that I should have mentioned. So this is all for today's lecture, and I thank you all for being with me. And if you have any questions, any concerns, any suggestions, please get back to me in that specific group, so I can entertain those suggestions and questions in our next lecture. And this is the end of our first chapter. So in this first chapter we had 3 lectures, lecture 1, lecture 2 and lecture 3, and I concluded them in 3 video lectures: video lecture 0, video lecture 1 and video lecture 2. So thank you so much for being with me. God bless all of us. Assalamu alaikum wa rahmatullahi wa barakatuh.